Welcome to today's oral argument docket at the First District Court of Appeal, and welcome also to anyone watching on our live streaming video. We're extremely proud to now be one of the longest state appellate courts in the country to have broadcast every oral argument live via the internet. And if y'all ever find yourself on a Tuesday, Wednesday, Thursday morning at 9 o'clock with nothing to do, you can tune in and see your colleagues in the well of this court arguing these fascinating cases. We're going to, housekeeping first, we're going to take the cases in the order in which they appear on your docket. We'll take a recess after the second case, 10 to 15 minute recess, at which time we invite you to join us in the attorney commons, which is to your right through these doors, as most of you know. I'll also mention to you, although I feel like you may have already been told this, that little clock down there, it's not like one of those play school type of things. That's actually a clock that actually counts down the time that you have. And when that yellow light comes on, this is the critical part, guys. That does not mean that you're into the last minute or 2 minutes of your opening argument, appellants. That means you're into your rebuttal time. And I will tell you that with 4 lengthy cases on the docket, we're going to stick pretty close to the allotted time today. I believe these are all 15-minute cases except for the first one. So the first case will be Agency for Persons with Disabilities versus Dallas and State. We'll hear from the appellant.
May it please the court, counsel? I'd like to reserve 5 minutes for rebuttal, please. My name is Julie Waldman. I represent the appellant, Agency for Persons with Disabilities. This is a case about services and how they are defined. The legislature charged the Agency for Persons with Disabilities with providing services to individuals with developmental disabilities in broad ranges of categories, from voluntary to involuntary commitments, from residential placements to community outreach programs, from developmental disabilities waiver programs to institutional settings. But they all have one element in common. They are all services from the agency for which an individual must be eligible in order to receive them. And so the question then becomes, who gets to make the determination about whether someone is eligible to receive those services?
I'm assuming that the description you've just given us describes the agency's responsibility not under the statute or the chapter that applied to the incompetence proceeding. Is that correct?
That's correct, Your Honor. It applies under Chapter 393 of the Florida statutes, which is the chapter that provides for services for developmental disabilities. And the chapter relating to competency is Chapter 916. However, it is the agency's position that the statutes must be read in conjunction with each other, because throughout Chapter 916 and the references with regard to mental retardation, these statutes, Chapter 916 refers back with regard to the definitional standards, with regard to all the other standards of proof, to the definitions within Chapter 393. And so you cannot read Chapter 916 and the definitions within it as to mental retardation in a vacuum. You must go back and look at Chapter 393 in order to be able to understand how the developmental disability statute works and how a person can be determined eligible for services.
So what you're saying then is Chapter 916 imports the responsibilities of the agency under a different chapter in a completely different setting, in a non-criminal setting?
Well, what I'm suggesting, Your Honor, is that Chapter 916, because it references in its standard for describing the definition of retardation, in fact, in Chapter 916.106, where it defines retardation and says that an individual must have retardation in order to, as part of the definition for incompetent to proceed, it refers back to the definition of retardation as in Chapter 393.063, and it specifically recites the same definition as found in 393. So I don't think that you can say Chapter 916 can only be read without referring back to 393 and the definitions within 393. And I think that once you do that, and once you look at the definitions and see that those definitions are the same, you then have to also look at what those definitions require. And those definitions require that the eligibility issues are the same for both statutes, because the standards are the same. And services is a broad range of categories. And services, whether they be competency training services, whether they be residential services, whether they be behavioral services, or any other of the broad array of services that the agency provides, are still services for which a person must be eligible to receive as determined by the agency. The problem becomes that if there is no bright line in terms of who can be eligible to receive services, then what we have is a standard without any definition. And we have a situation where any person can be ordered to receive services without any definitional standard for deciding how that person is entitled to services, other than a court deciding that there is no other alternative, so I'm going to place them with the agency for services. Part of the issue, and particularly in this case, which is quite illustrative of the concern that the agency has, is it's not just a situation where this individual is receiving competency training. He was also ordered into residential placement. And residential placement is another service for which the agency is now being ordered to provide services for someone who the agency believes is not eligible for that service.
In the agency's view, how would this unfold over in the criminal court?
I'm sorry, Your Honor.
How would this situation unfold in the criminal court when the judge makes these findings? What would the judge then do in the view of the agency?
Well, the defendant is required to present evidence by clear and convincing, or present proof by clear and convincing evidence that they meet the definitions.
Well, you're not challenging the judge's substantive adjudication here of incompetence, are you?
Yes, Your Honor. I believe that within the body of the brief,
do you have standing to challenge that?
I believe we do have standing to challenge it, because if the court orders.
Why can't the Department of Corrections challenge a finding of guilt then?
Well, I don't know, Your Honor. I'm not really sure of that. I haven't researched that issue. But I believe that if the agency is being required to provide services to an individual.
Well, see, I don't mean to interrupt, but my impression of this case has just changed, because I thought your challenge was to the requirement that you provide services, which you claim is sort of a de facto reaching into your executive branch pocketbook and requiring you to expend money.
Yes, sir.
But you're saying you're actually challenging the trial court's adjudication, I guess under Chapter 916, that this particular defendant was incompetent due to mental retardation.
Oh, I apologize, Your Honor. I misunderstood your question. We're not challenging the trial court's adjudication of incompetence. We're challenging the trial court's adjudication of incompetence due to mental retardation and ordering him to our services.
Well, that's what I was concerned about. You're asking us not only to reverse the placement, but to reverse the trial court's finding of incompetence due to mental retardation. Is that right?
The finding of mental retardation is a finding that the court can make, but the finding of mental retardation and then a finding of eligibility for services I believe are two separate tracks. And I believe that there were experts who made determinations that this particular individual was mentally retarded. But mental retardation can occur from many other factors besides having a developmental disability. And the question then becomes, what the trial court did in this particular case was make a finding that the retardation.
This is 18-year-old, the pre-18 years old, that
yes.
sort of thing. Okay, let me get back to my first question, which is how would the agency have this thing unfold? You're in the trial court, you got somebody languishing or whatever you want to call it in the county jail, awaiting trial. There's every sign that this person is mentally retarded or autistic. Maybe he's not, but there's every sign that he is. And the trial judge seems to be doing what he thinks the statutes require, as does the state attorney and the public defender. How would you see this unfold?
Well, Your Honor, with all candor, this is a situation that courts are struggling with, and in this particular case, this judge has struggled with this issue in many other cases, and I've been before him on these issues, because there is a gap in the law with regard to what do you do with someone who is incompetent to proceed, who does not meet the definition under Chapter 916 and 393 for mental retardation with a developmental disability, who does not meet the other standards for mental illness, but yet is incompetent to stand trial. And right now, the law has not caught up with the reality of circumstances where there are individuals who may be incompetent to stand trial and who are not capable of meeting the standards required to proceed to trial, but yet at the same time, the agency cannot be the
Go ahead and tell me
fail-safe.
what the judge is supposed to do. That's the tough question for you.
I don't have an answer, Your
Send
Honor.
him back to county jail in perpetuity?
Well, I don't have an answer for that, unfortunately, because the law hasn't created an answer for this yet.
I mean, so the state has to. If you're taking the position that if the judge can't do this, I think you have to tell us what the judge should have done. I know it's a tough question. That's why you're here. That's why we're giving you 20 minutes. But what is Judge Nyland and whoever else deals with this supposed to do next week?
Well, the problem is, Your Honor, with all due respect, that the judge can't just say, well, because I don't have any other alternative, I'm going to send him to the agency. Because he doesn't qualify for services with the agency. He's not eligible for services with our agency. And then what that creates is that we become the fail-safe or the backup for every person who's incompetent but may not really qualify for our services. Of course, that then creates a backlog of people who may be eligible for our services in other instances that we cannot serve because we're serving people who are not competent or who are not eligible for our services. Interestingly enough, in this particular case, Your Honor, after the agency made a determination that this individual was not was not eligible for services, there was no challenge pursuant to the Administrative Procedure Act, which he's entitled to, with regard to his denial of eligibility. So this particular individual who was determined to not be eligible for services through us has not even taken advantage of the issues with regard to his own denial of eligibility as the statute provides for.
I'm guessing he may not understand what's going on here. He may not be thrilled with the prospect of commitment to an state institution any more than the institution is thrilled with his commitment.
Well, that may well be, Your Honor, and that is another aspect which, of course, any person who is charged with a crime and is incarcerated, whether it be in an institutional setting or a jail setting, is probably not thrilled with their circumstance. But I don't know that necessarily, considering that this particular individual has been represented throughout, I'm not sure that his individual understanding, with all due respect, Your Honor, I'm not sure that his individual understanding of his rights under the law would...
I raise that only because you were suggesting that he has a remedy, has an administrative remedy if he doesn't think he should be committed or if you don't think he should be committed or whatever the situation.
Yes, Your Honor.
What I'm saying is I'm not surprised he didn't pursue it.
I understand, Your Honor. I think that the fact that the overriding fact that the statute, that 916 requires that the defendant provide by clear and convincing evidence that that defendant prove by clear and convincing evidence that they are retarded as defined by Chapter 393 using the same standard, which is the sub-average intelligence and the sub-average adaptive functioning prior to age 18, is indicative of the fact that 393 should control and the eligibility issues must be considered with regard to how these determinations are made.
But counsel, excuse me.
Yes, ma'am.
Even though the definition of mental retardation from Chapter 395, is it?
393, Your Honor.
Applies in Chapter 916 proceedings. I get that. But the proceedings that the agency is involved in, the administrative proceedings of determining whether or not someone is eligible, presumably upon application to APD, eligible or ineligible for services, is an administrative proceeding. As you just indicated, Mr. Dallas could have challenged the agency's finding at DOE. Chapter 916 is a strictly criminal proceeding. It's part of the criminal framework that we have here in Florida. How is it, or why is it that the administrative proceedings should be able to bleed into the criminal proceedings? That I don't understand, and especially when in Chapter 916 the description of the agency's responsibility appears to be mandatory. It is. When that determination is made by the trial court, APD shall treat that individual that's deemed incompetent.
Well, I think, Your Honor, that there are two issues at play here. One is that I don't believe that the administrative the administrative processes bleed into the criminal court's jurisdiction.
That's what it sounds like to me, if you're suggesting that basically APD's determination of eligibility for services trumps whatever the trial court decides.
Well, Your Honor, I think what I'm suggesting is that APD is the agency that really has the diagnostic capability to make determinations about eligibility far more so than a trial court would have. And I think that the legislature understood that when giving them the deference to, not the deference, pardon me, when giving them the authority within Chapter 393.
Well, let me ask you, go ahead, Judge.
But counsel, doesn't 916 expressly state that the court is to find that the defendant has retardation or autism? And certainly within 916 they define what the agency is, that it's APD, and what the responsibilities are for the agency to train. If the court or if the legislature felt that it was incumbent upon the agency to determine who was retarded or not, then why would they use this express language in 916.302 that is the court to find that the defendant has retardation by clear and convincing evidence?
Well, Your Honor, that's actually a very good question, and that's part of why I brought this appeal, because I think that there is a gap within the two statutes and the interplay between them, and I think that this court has the opportunity to remedy that by expressing that it is the agency that makes those determinations and not a trial court, that the legislature in not
But that's not really responsive to Judge Rowe's question, because she's citing a statute, and there are probably 2 or 3 statutes in these 2 chapters that talk about a finding by the circuit court.
Well, 916.302 does require that the court make findings with regard to retardation, as Judge Rowe indicated, and make that finding by clear and convincing evidence. But as I suggested earlier, and I apologize if I was not responsive, but makes the findings by clear and convincing evidence that the definition, again, goes back to 393, and that's where I think...
Counsel, isn't the court competent to apply that definition? I mean, certainly the court can look at the reference back to Chapter 393, see what it means, and apply that in determining whether the defendant is retarded or not.
I'm not certain, Your Honor, with all candor, that the court can make that determination without the diagnostic capability that the agency holds. And I think that in cases like this, that it should be the agency that has the authority to make these eligibility determinations as outlined in 393. I think 916 has sufficient references back to Chapter 393 to allow for that eligibility. And for these reasons, I think that the eligibility determinations, including eligibility for competency training, whether it be outpatient competency training or restoration training, should be done by the agency.
Let me ask you one other question. I know you're looking at the clock. We appreciate that. I'll give you time. But does your argument go so far as to say that in this particular proceeding, Mr. Dallas, say that, I'm not sure if he had 1 or 2 of these competency things, but say he has one and the agency gets notice, and Judge Nyland or whoever else is the judge says, no, he doesn't meet the statutory standard. Does your argument go so far as to say the agency could say, oh, yes, he does, and we're going to take him for services at Chattahoochee, you need to release him from the Alachua County Jail?
I don't know, Your Honor, if the agency would ever argue the opposite.
I'm not saying no agency would ever argue it. I'm questioning whether that's not the logical upshot of your argument here today.
To be honest with you, Your Honor, I haven't thought it through to that extent to be able to answer your question. I'm not certain if that would fall into that way. I would have to give that some consideration. In any event, the agency would request that you grant the petition for writ of certiorari and overturn the lower court's order ordering Mr. Dallas into agency services.
Thank you, Ms. Willis. I guess we'll hear from the state of Florida. We just heard from the state. We'll hear from the state again, I guess.
Edith Sheeks, Your Honor, Regional Conflict Counsel for Travis Dallas, defendant. And, Your Honor, we would submit in the beginning that this case does not meet the statutory or the standards for an extraordinary remedy of granting certiorari. The trial judge did not act in excess of his jurisdiction. He clearly followed the statutes that the legislature created, and he didn't depart from the essential requirements of the law.
This is an odd case because they're saying, in essence, that your client is illegally confined, and you're saying, oh, no, he's not.
Your Honor, I'm very well aware of the irony of this. Our concern is that in this case, Mr. Dallas, who had sat in jail for a very long time waiting services, was found to be incompetent by Judge Nylund after due hearing where he listened to 2 experts testify. He heard all of the evidence, and he, in his best judgment, and as he has the authority to do, determined that Mr. Dallas was incompetent. He then, as also he has the authority to do under Chapter 916, as Your Honors have already pointed out, directed that he be sent to the Agency for Persons with Disabilities for incompetency training services. The judge did specify the specific place where Mr. Dallas would be treated, but he only did that because that's the only one available.
Is that comment then a nullity or superfluous?
Yes, Your Honor, I believe it was. In terms of how the case law in these cases, when the judge has been found to have exceeded his authority, there's a line of cases, and 2 of them recently from this court, saying that the judge exceeds his authority when he specifies the treatment and how the funds should be spent. This judge didn't do that. He just said he's incompetent. After examining all the evidence, he reached that conclusion, and he said that he needs incompetency training, and their only option was the Agency for Persons with Disabilities. My esteemed colleague began her remarks by saying this is a case about provision of services, and we would submit, in contrast to that, that it actually has to do with an interpretation of the statutes. Chapter 916, the legislature clearly delineated that the trial judge was within his authority to make these decisions. The only reference to Chapter 393 was the definition for retardation, and 393 says in criminal cases, Chapter 916 shall control. So we believe that in this case that the trial judge, Judge Nylund, did exactly as he was supposed to do, as the legislature intended for him to do, and that he did not in any way exceed his authority. So there is no reason for granting cert. It is very unfortunate, and I believe the agency's counsel is wrestling with this dilemma, that the setup in Florida in terms of how these criminal defendants who are incompetent or have mental disorders are dealt with, it's a scrambled system, and the bottom line is there's a lack of money for treating these people. It's very clear from the trial transcript in this case that Judge Nylund was aware of this, deeply aware of it, and wrestling with it. He did the best he could, and he did exactly what the law told him he should do. And we would submit that this court should not grant certiorari, should uphold Judge Nylund's order.
Let me ask you, I always like to ask where your argument leads, and you can see from
Yes, that's
your
right.
opponent that I do that. But I'll pick on you.
Sure.
If Judge Nylund had said, well, you know, I've read these statutes and I'm real familiar with the Florida Constitution, and I don't think I can require the executive to do this, but I do think clear and convincingly that this gentleman, Mr. Dallas, is suffering from mental retardation or autism. So therefore, I'm going to postpone the trial, and he'll just have to stay in the Alachua County Jail. What would your position be if that had happened?
In terms of representing Mr. Dallas, there would be, I believe, a due process
I guess what I'm asking
challenge.
you, that's what I'm asking you.
Yes.
Would he have a due process right to the treatment of the statute?
Yes, Your Honor. We would submit that he does. And as I say, this is not, it's not an easy issue. The statutes, the legislature made their will clear in Chapter 916, and it's a mandatory statute, and the agency doesn't have any discretion in that at all. And in terms of that, my perception of what the agency's arguing is actually the reverse of what they submitted in their petition for certiorari, saying that to order the agency to do this intrudes on their constitutional authority. I believe it's just the opposite. By them saying the trial judge doesn't have the power to do this when the legislature told him that he does, is the agency intruding on the judicial authority of the courts, and is clearly specified in Chapter 916. So it's kind of
Did this particular case arise? I'm just curious. In looking at the specific facts in this case, you have one individual who is going through the criminal system. He's deemed incompetent and in need of involuntary commitment and treatment. But the same individual evidently applied for services on a whole different track. I mean, isn't that really what has brought this case to where it is today? I mean, I would suspect that it doesn't often happen that you have sort of the two different tracks going on at the same time with one individual.
Your Honor, I am not certain in terms of my answer to that, but my suspicion is that's not the case, that this criminal case, because of his condition and what happened in it, that anything he might have done individually or a civil way to get services is really not pertinent to what happened in the criminal case. And I believe, Your Honors, if my reading of the case law in Florida is correct, as I said earlier, it appears very clear that in cases where judges order services like this, Hadi, for example, if the judge is specifying that the defendant is incompetent and needing services, that's acceptable. That's been found to be within Chapter 916. It's in the cases where the judges have gone further and said, well, these are the specific services, or you need to do this for him or her or that. Those are the ones where the judge's ruling has been overturned as exceeding his authority. Judge Nyland did not do that in this case. He was very clear, and I think the transcript shows he was very well aware of what his authority was in this case and what he had to do in the case. And it was rather poignant reading because he's aware of what's happening in these cases all across the state. So we would submit that Judge Nyland's verdict needs to be upheld, that the writ for certiorari needs to be denied, petition for writ for certiorari.
Thank you, Ms. Sheets.
Thank you.
Is Amicus going to argue?
No.
She said yes. But we've already ruled.
Just a few points to clarify, Your Honors. Petition for certiorari is the only opportunity the agency has to challenge these types of orders, because if the agency waited until the competency training had occurred and then appealed a final order, the training would have already been provided and there would be no opportunity to challenge the training prior to it occurring, and it would be a situation where the agency would effectively have no remedy. And that is the primary reason why the agency has chosen this avenue. The agency's position is that the judge did not follow.
You would have no judicial remedy.
No judicial remedy, yes, Your Honor.
Some people might look at this case and see it as simply a dispute about dollars allocated amongst executive agencies by the legislature, and not see a judicial issue.
And that may be the case as well, Your Honor, and that certainly has to be a factor. The agency has to live within budget realities, and some of those realities indicate that we can only serve people who are eligible in order to be able to serve as many eligible individuals as possible. Unfortunately, that is a situation that the agency is faced with. And I do want to be clear that as counsel did point out, we are not appealing the judge's order in any way related to an ordering of specific services. Obviously, when someone is ordered to involuntary commitment, there is only one place currently available for involuntary commitment, and there's nothing that I've presented either in my briefs or perhaps it was inadvertent, but there's nothing I intended to present appealing any sort of issue related to specific placement. That's not an issue at this time in this case, because there is only one place available for competency training in an inpatient facility at this time. In the instant case, the agency's position is basically this. This defendant does not meet the eligibility criteria for services, and the agency should be the entity that is entitled to make those eligibility determinations. In a broader sense, the agency should be entitled to make those eligibility determinations overall for individuals in these types of situations. The only remedy that the agency has to address issues like this prior to final orders being issued is a petition for writ of certiorari. For all of these reasons, the agency requests that you grant the petition for writ of certiorari and overturn the lower court's order. Thank you very much for your time.
Thank you to both sides for your thoughtful advocacy.